Good afternoon, Chief Justice Rehnquist. On behalf of everyone assembled at Duquesne University in Pittsburgh, as well as the Harry S. Truman Presidential Museum and Library that's co-sponsoring this event, I'd like to thank you for participating in this special program. I have just a few questions to set the stage as we begin this retrospective, looking back 50 years in history. You were just a 27-year-old law clerk, clerking for Justice Jackson, only a few months in Washington at the time the Steel Seizure Case landed in the courts. At the time, was this a case everyone expected would be a constitutional landmark? What was the atmosphere surrounding it?
The atmosphere, so far as one living in Washington was concerned, was very much that it would. The law clerks talked about it at lunch, and it wasn't just the Supreme Court arguments in the case that received press coverage. The arguments before Judge Pine in the district court were front page news in the Washington papers, perhaps not elsewhere.
And did you and your fellow law clerks have any prediction what would be the final outcome when it worked its way through the Supreme Court?
Oh, I don't think most of us knew what position our justices would take. We did have a vote at lunch one day, and I think, as I recall, we were evenly divided, but that was not on the basis of what we thought our justices would do, because most of us didn't know.
And what do you remember most vividly about the oral argument? I believe it was May 12th of 1952.
Well, the fact that John W. Davis argued for over an hour and I think was asked only one question. I mean, he had a style of advocacy that you don't hear nowadays, but it was very impressive. And then Solicitor General Perlman got a whole bunch of questions from the court.
And Arthur Goldberg participated as well?
Yes, he participated in oral argument for the AFL-CIO, I believe.
Right, for the steelworkers, yes. And in your book on the Supreme Court, you tell a wonderful story about the Justices' Conference that Friday, at which they voted on the case in private. What do you remember about that?
Well, as I say, of course, the clerks weren't present at the conference, but George Niebank, my co-clerk, and I were just as dying to find out what happened, as I suspect all the other clerks were too. So we followed Justice Jackson into his office when he got back, just as we always did, and he would tell us what happened at the conference. And he said, "Well, boys, the president got licked."
And Justice Jackson's concurring opinion in the Steel Seizure case is generally regarded by constitutional scholars as the most significant. What did he say about presidential powers, and why did he write separately?
Well, I think he wrote separately because almost everybody did write separately. I think the opinions had to be prepared in a fairly short time, and I think even those who agreed with Justice Black's outcome felt that there needed to be more said about the thing. And Justice Jackson's concurring opinion classified presidential power in three different ways. First, where he was acting with the approval of Congress, and there Jackson said, only if the whole government is disabled does he lose. Second, where he's acting without congressional authorization, but without congressional disapproval, and there it's kind of a middle ground. And finally, what Jackson felt had happened in the Steel Seizure case, where he was acting in an area where Congress said, don't do what you want to do something else. And there he said the power is at its nadir. Right.
And did public opinion, do you think, influence the court's ultimate decision that President Truman had exceeded his constitutional power?
I think it did. The government made some extraordinary claims at the very beginning in the district court that the president had all the authority that George III had unless it was taken from him by the Constitution. Well, you can imagine the press outcry about this. I mean, it just made headlines. And it just gave a negative aspect. The government abandoned that argument long before it got to the Supreme Court, but it just got the government off on the wrong foot.
And there was an ambivalence about the Korean War even at that point, wasn't there?
Very much so. There were people fighting and dying in Korea, but very few sacrifices called for on the home front. World War II, I'm not that old. World War II, you had 14 million people under arms, but a lot of things restricted on the home front. The Korean War, you just didn't have those restrictions on the home front. So there was just a real ambivalence, as you say.
Yes. And what would you say is the lasting significance of the Steel Seizure Case as we look back in constitutional history 50 years?
Well, I think the subsequent opinions of the court have adopted Justice Jackson's concurrence, and that kind of trifurcation is probably its contribution. I think people have expressed the view that had it come up in time of declared war, it might have come out differently. And so, you know, it's just one of many cases in this area, but I think the Jackson concurrence has been pretty much what it stood for.
And I'm reminded that one of the great things about a retrospective like this is it allows us to learn history from key people who actually participated in it. So your recollections are particularly relevant and meaningful, and it puts us in a good position now to step back a half century and examine a presidential decision that's really largely been lost to history books and law books, but is still highly relevant. So thank you very much, Chief Justice Rehnquist, for introducing today's program.
It's been a pleasure to be here, Professor Gormley.
Thank you.